Being said, the 455th District Court is now in session. The Honorable Judge Eiserloh presiding.
All right, good morning, everyone. Judge Eiserloh here in the 455th Civil District Court here in our beautiful Civil and Family Courts facility in Austin, Texas. Our first case this morning is Ms. Stevens's case. I'm going to call the number and then Ms. Gonzalez, if you would, let's go in and take a record so that we have, since I don't know what's going to happen, if you would please, let's take a record in this. We're here on a motion for entry of judgment. We have been having some trouble reaching out to the parties. It does look like Ms. Stevens is here today. Ms. Stevens, could you please tell us who you are and what you're wanting from the court today?
Hi, yes. Good morning, Your Honor. Again, my name is Amika Stevens. We was actually here to try to get the hearing finalized, but it's been some issues and some difficulties since last court. A matter of actually understanding everything that's really going on and actually trying to process it. I have, to a certain extent, received a document from a councilman, which I'm not sure as to how I can actually review it or reference it because the document is not actually properly numbered or in order in any fact. So whereas I can state my issues, and not only that, it is not addressed to me by hand, which by my name itself, by my full name. The name throughout the document is not actually pertaining to myself. So there's been an issue with this attorney about that, because this has been done already with the temporary orders. So, as for your request, submitting my W-2 to the attorney, where I've submitted legal documents with my official name, and to receive a order that is not actually addressed to me, I really don't know how I can address that matter or to go about it.
No. Let me ask you, can I ask you a couple of questions? What I remember about this case was that you and the child's father were joint managing conservators. The father had the primary with the geographic restriction of Travis and contiguous. In other words, y'all were going to live basically in this area, either in Travis County or, counties around it. Could be Williamson County or Hayes, You were to provide us some income tax info from 2023 to the father's attorney. I don't know if you did that or not. And then
I did, Your Honor.
Good, okay. And then we were going to provide 14 days to determine some child support issues. And then not you, but the father, his attorney, was supposed to provide me with a proposed order by the 1st of July, by the 1st of July, and then giving you, 24 hours to review it. Did that ever happen? Did he ever get that to you?
It was probably late last week when I actually saw the email as well. For court, he actually did respond to me about the W-2 text that I sent to him, stating he's not sure as to why I'm sending it, but that was one of the requirements by the court.
Yes,
so,
it was.
That was our little conversation, and like I said early on, there was a document received. Again, is not addressed to me, meaning by my government name. So I don't know how to go about even
but the document
admitting or to even agreeing to anything that it's asking me to do. I also have issues and some concerns about it. You also stated about child support, and that was one of his main reasons. And but
here's what I want you to do. That order that he sent to you, I understand it may not be by your correct government name, but is it called something like order on SAPSIR or something like that? Is it called order?
Yes, it was saying the final orders.
Why don't you take some time and review it? And if there's parts of it that you aren't liking, now remember, you have an order. I'd already given an order in the case, and I know that some of that wasn't what you wanted, and some of it was, a very little bit. But so don't take out the stuff that I already ordered because you don't like it. I mean, if there's in terms of my order, try to go through it, and if there's any changes to it, just write them in, and then send it to the court. Do you have I'm going to give you my email address, okay?
Yes, Your Honor.
And Ms. Stevens, if you would make sure that you carbon copy, where it says CC, make sure that you copy Mr. I'm sorry, the father of your child, and I'm just forgetting his name right this minute, but make sure that you carbon copy him and his attorney when you send that to me so that they know you sent it to me, okay? And I think that would help us a little bit. Let me see, my staff I know have been trying to reach out to both of you all, and you were very kind to get back to us. I really appreciate it. Hang on a minute, let me see what they say. Well, we've apparently we're trying to reach out to his office right now, to the attorney's office. Why don't
Yes,
we
Your Honor.
let's go to the next case, and if he comes in, then we'll come back to you, okay?
Yes, Your Honor. Thank you.
Okay, well, just so Hank, we'll get back with you, all right? But don't leave. Thank you, Ms. Stevens, okay?
Thank you.
All right, very good. 061 James Logan versus Gene Idle. We're hearing a motion to withdraw. May I please have any announcements?
Yes, Judge Jenna Cornejo on behalf of the plaintiff, James Logan. We also have Mr. Gene Idle, who's on the Zoom as well. He's a pro se defendant in the case.
All right, welcome, Ms. Cornejo, Mr. Idle. All right, who's seeking, Ms. Cornejo, are you seeking to withdraw?
Yes, Judge, we're seeking to withdraw from Mr. Logan's case at this time. Mr. Logan has received notice of this hearing as of July 9th, 2024 by certified mail. So we are just seeking to withdraw today, Judge.
All right, very good. Mr. Idle, do you have anything to say on this?
No, Your Honor, I don't.
All right, very good. The motion to withdraw is granted. Ms. Cornejo, I ask you to please email a copy of that order to us, and it's that same email address I just gave to the previous litigant. It's 455.submission@traviscountytx.gov. Again, 455.submission@traviscountytx.gov. So what I want you to do, if you would, is write in the subject line, write HO in the cause number. HO stands for hearing order in the cause number. And if you would, please get that to us by noon today, okay?
Yes, Judge, we'll do that. May we be excused?
You may be excused. Thank you. Have a wonderful day. This
Yeah.
is
Thank you. You
Alyssa and Brandon Wallace versus Epiphany Dermatology, Alan Hatter, and Walmart stores. May I please have announcements?
Grace Weatherly and Paula Sweeney for the plaintiff.
Welcome. Who else is here?
Terry Harris here on behalf of Dr. Hatter and Epiphany Dermatology.
Welcome, Ms. Harris. Who else is here?
David Watson on behalf of Walmart stores.
Welcome, Mr. Watson.
Good morning, Your Honor. Luke Dow, guardian ad litem for the minor.
All right. Thank you, Mr. Dow. All right. Very good. So we're going to, I understand there's several parties here, and we are probably going to have to swear in some witnesses. If Mr. Dow, whom do you anticipate will be testifying today?
It should be both parents, Alyssa Wallace and Brandon Wallace.
All right. I see Miss Wallace here. I don't know that I see Brandon.
They're both here, Judge. Y'all turn your cameras back on and unmute yourselves, please.
Okay, there you are. All right. I'm asking both of the Wallaces now. Please raise your right hand. Do you hereby solemnly swear or affirm the testimony you shall give in this cause will be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
All right, very good. All right, Mr. Dow, you may proceed.
Grace, do you want me to do it or were you doing it?
Oh, I can start with the questions. I'll just say thank you, Your Honor. It's a pleasure to meet you. We're here on a medical malpractice case today.
Yes.
I
believe we know each other, Ms. Weatherly. I think we've met each other in Santa Fe at that.
Oh, that's right. That's right.
Yes.
I'm sorry, I forgot.
It took me a minute, but your name I did recognize. So welcome.
These squares are little tiny on my computer.
Yeah.
Grace,
Yes,
Grace,
sir.
before you get started, Judge Eiserloh, I had emailed Ms. Gordiola this is a confidential settlement, so we're not going to be putting numbers on the record.
All right.
So I sent you a memo outlining the entire settlement, the net, and what's being done with the miners' funds, just so you could see what we're doing without us actually talking about it.
Thank you.
Sorry to interrupt.
No, that's helpful, Mr. Dow. My staff and I have received that, and thank you for that reminder. All right, very good. Ms. Weatherly, you may proceed.
Thank you. I think the easiest way to explain the case is just to call the witness and you'll hear the story, and we will call Alyssa Wallace.
All right. Ms. Wallace, I've already sworn you in. You are now on the stand. The testimony that you shall give, although we're here on Zoom and it's a more casual setting, it's as if you were in court here in Travis County giving testimony. And again, you are under oath. Ms. Weatherly, you may proceed.
Thank you, Your Honor. Alyssa, state your full name, please.
Alyssa Wallace.
And you are the mother of Alyssa?
Yes, ma'am.
Alyssa, you brought this lawsuit against Dr. Hatter and his group and Walmart Pharmacy related to the prescription of retinoid medication for you in April through September of 2020, correct?
Yes, ma'am.
And while the retinoid didn't harm you, it harmed your daughter, who was born then a year and a half later, correct?
Correct.
In fact, Olivia was born with severe birth defects, including a brain tumor, cleft palate, and a spina bifida, among other conditions, correct?
Yes, ma'am.
And at this point, it appears Olivia is meeting her markers. She's doing well cognitively and physically, walking, talking, sitting, and eating, correct?
Yes.
Okay. So you were aware that Dr. Hatter and his group raised a defense that although Olivia wasn't actually born within the 2 years since the time that you were taking the medication, but nonetheless that your claim and Brandon's claim for medical expenses until she turned 18 was barred by limitations. Do you remember that?
Yes.
And Walmart also raised two defenses: one, that they had no duty to warn you, and two, that they did in fact warn you. You recall those defenses?
Yes.
Nonetheless, we were able to negotiate a settlement for you, and you're asking the court to approve that settlement, correct?
Correct.
Now, the divisions of the proceeds that are outlined in the confidential in-camera settlement memo include $50,000 to go to each you and Brandon, correct?
Yes, ma'am.
And you believe that that division is in the best interest of Olivia, correct?
Correct.
And the remainder of the settlement, net settlement, would go to $750,000 in attorney's fees that would be divided between me, my firm, and Paula Sweeney's firm.
I have to interject. We weren't going to put any numbers on the record.
Okay,
It's confidential.
It would appear that we do have something called confidential in-camera settlement that's been provided to the court, and I'm looking at it right now.
Yeah.
It was, at least the copy I'm looking at was not signed by the parties, but it was provided as if it were part of this case. So, Ms. Harris?
Yeah, our intent the intent of all the parties was to have you have that so we could just refer to that piece of paper without saying numbers on the record.
All right. Thank you, Ms. Harris. Ms. Weatherly, I do have that piece of paper just so that you'll be reassured.
Okay. That's correct. I didn't think the fees and expenses were confidential, but you have them in front of you. The question for Alyssa is, do you approve the division of this settlement to pay those fees and expenses?
Yes, ma'am.
And then there would be about a small amount of money left over for any expenses that came in after today. You remember that?
Yes, ma'am.
And you approved that?
Yes, ma'am.
Now, there was a huge TRICARE lien that has been waived. You learned that yesterday, correct?
Yes.
So that's happy news. And it results in a net settlement that you're asking the court to approve, a lump sum that would be deposited into a trust that we're asking the judge to authorize the creation of this trust today, right?
Correct.
And then a series of annuity payments that basically cover Olivia through early adulthood, and then another annuity that covers her for life, correct?
Yes.
And you know that Mr. Sutter, who's on the phone here today, is the trust officer for the bank that will hold the trust account.
Yes.
And all of this is an agreement that you are asking the court to approve because you believe it's in the best interest of Olivia, correct?
Yes, ma'am.
And you understand that these payments will be assigned to an insurance company, USAA, who will hold the annuity, issue the annuity.
Yes.
Okay. And you understood that by doing this, you're going to waive your right to a jury trial.
Yes.
And you understood that if you'd had a jury trial, you could have lost, you could have won more, or you could have won less.
Correct.
And you understand that you can't go back later in the future and say, I didn't get enough money, I want to sue again.
Yes, ma'am.
You understand you'll be releasing these defendants for all time for Olivia's damages.
Yes.
I'll pass the witness.
All right, very good. Ms. Harris, do you have any questions for this witness?
Only a couple. Hi, Ms. Wallace. Good to see you again.
Yeah.
You've had a chance to meet with Mr. Dow, the ad litem, correct? Talk to him?
We have not spoken yet, no.
Okay. You understand he's been able to review your file and talk to your attorneys?
Yes.
And that between your attorneys and him, they've been working to set up the trust and the annuity on behalf of Olivia in order to make her money over time and to give her money over time, correct?
Correct.
And you've been able to look at all those numbers and understand where all the money's going?
Yes.
And after talking to your attorneys and seeing all of those documents, you are asking the court to approve this settlement because you think it's in the best interest of Olivia?
Yes.
Nothing further, Your Honor.
All right, very good. Mr. Dow, do you have any questions for these witnesses?
Just real briefly, Ms. Wallace, I think we had a phone call, not a Zoom and certainly not an in-person meeting, but we had a phone call. I don't know, it might have even been over a month ago, just to clarify. I don't know if you remember that or not.
I don't.
Okay.
Was it the mediation?
No, it was with, it's okay. But just to reiterate, you understand the finality of this settlement and specifically what we're doing with the trust and the structure that's going to pay into that trust, correct?
Yes.
Okay, and you believe all of that is in Olivia's best interest?
Correct.
Okay, thank you, ma'am. I'll pass the witness.
All right. Mr. Watson, do you have any questions?
Yes, Your Honor, just a few. Good morning, Ms. Wallace. My name's David Watson. I represent Walmart Stores. Just a couple of questions along the same lines. First, do you understand that this agreement is a full and final settlement of any and all claims that could be brought now or in the future against defendants in connection with the facts alleged against Walmart?
Yes.
And you understand that once Olivia reaches majority, she could not bring another lawsuit under the same underlying facts?
Yes.
And do you understand that this full and final settlement agreement is confidential?
Yes.
And are you entering into this settlement voluntarily?
Yes.
And do you agree that this settlement is fair and in the best interests of Olivia?
I do.
And are you asking the court to approve the settlement in this matter?
I am.
Thank you. Nothing further, Your Honor.
All right, thank you, Mr. Watson. Mr. Sutterth, I don't mean to leave you out. Do you have any questions for these witnesses?
No, ma'am, I do not.
All right, thank you, Ms. Sweeney. I don't mean to leave you out. Do you have any questions for these witnesses?
No, Your Honor. I think it's been covered.
All right, very good. think that we are finished now with this witness. Thank you, Ms. Wallace. You may figuratively step down from the witness stand. And I'll ask Ms. Weatherly, please call your next witness.
We call Brandon Wallace.
All right, Mr. Wallace, again, you've already been sworn in, so you're under oath. And although we're here in a casual setting in Zoom and appearing on camera, the hearing today and your testimony is formal, just as if we were in the courtroom and you were just sitting in our witness stand, okay? All right, with that, Ms. Weatherly, you may proceed.
Would you state your full name, please?
It is Brandon Donovan Wallace.
And Brandon, are you the birth father of Olivia?
Yes, ma'am.
And do you have an understanding of the claims that we brought as I discussed with Alyssa?
Yes, ma'am.
And you have an understanding of the defenses that were raised?
Yes, ma'am.
And do you understand the risk that if you go into a jury trial, you could have one more, one less, or lost?
Yes, ma'am.
And you understand that today's the day. You can't ever go back and sue again, and Olivia can't ever sue again for this injury to her.
Yes, ma'am.
Are you asking the court to approve the settlement as was divided on the disbursement sheet and in the confidential in-camera settlement memo?
Yes, ma'am.
And is it your opinion that authorizing a payment to you of $50,000 is in the best interest of Olivia?
Yes, ma'am.
And you understand that the trust officer will be the one who will manage the funds until Olivia reaches age 25, or that, and that may continue if Olivia is disabled at age 25. Do you understand how that works?
Yes, ma'am.
Are you asking the court to approve the settlement?
Yes, ma'am.
And do you believe that it's in the best interest of Olivia?
I do, yes. Yes,
I'll
ma'am.
pass the witness.
All right, very good. Thank you. Ms. Harris, do you have any questions for this witness?
I do not. I just want to say, Mr. Wallace, it's good to see you again. And again, thank you for your service. I understand you've recently got out of the military, but as we talked in your deposition, I really appreciate your service, but no questions.
All right,
Yes,
very
ma'am.
good. Thank you. Let's keep going. Mr. Dow, do you have any questions for Mr. Wallace?
No, Your Honor, thank you.
All right, Mr. Watson, do you have any questions for Mr. Wallace?
Just a couple, Your Honor.
Okay.
Good morning, Mr. Wallace. My name's David Watson. I represent Walmart. Just a couple of questions. First, do you understand that this is a full and final settlement of any and all claims that could be brought now or in the future against Walmart in connection with the underlying facts in this case?
Yes, sir.
And you understand that Olivia may not bring another lawsuit in the future relating to the underlying facts in this case?
Yes, sir.
And do you understand that this agreement is confidential?
I do. Yes, sir.
And are you entering into this settlement voluntarily?
Yes, sir.
Do you agree that this settlement is fair and in the best interests of Olivia?
I do. Yes, sir.
And are you asking the court to approve this settlement?
Yes, sir.
Thank you, Mr. Wallace. Nothing further, Your Honor.
All right, thank you, Mr. Watson. Mr. Sutter, do you have any questions for this witness?
No questions, Your Honor.
All right, again, Ms. Sweeney, anything further?
No, Your Honor.
Okay, very good. All right, let's go back to you, Ms. Weatherly. Do you have any additional witnesses?
I don't. We have Randy Sutter here if any party or the court would like to ask him any questions. Otherwise, we would ask the court to sign the decree creating the trust and sign the final judgment, which I assume will all be submitted to you if it hasn't been submitted to you. And I would just close and turn it over to Mr. Dow for his report.
All right. Thank you, Ms. Weatherly. All right, Mr. Dow, anything for the court?
Yes, Your Honor, it's an appropriate settlement. You heard of the.
Let me just stop you because I think that we had a little glitch. It is an appropriate settlement. Is that what you said?
It is an appropriate settlement. I'm sorry.
Somehow when you in the Zoom, it's cutting it off and sounding like inappropriate, which is why I stopped you to say it again. The settlement is appropriate. Is that what you're saying?
It is in the minor's best interest and it is appropriate.
Okay, thank you.
Your Honor, one of the reason we did the trust and the structure into the trust is in the event that right now Olivia is doing really well. You heard that she's hitting all her benchmarks. She's had a few surgeries that have been very successful. So she's hitting her milestones right now. And I think she's doing very well considering everything that she's been through. The trust is in the event that, she becomes, if she needs Medicaid, Medicare, the trust will protect those benefits. If it turns out she does not need those benefits, the trust will dissolve at age 25 and she'll get what's ever remaining, and then the structure payments will revert to her. So the amount of the settlement is appropriate. There would be, to move forward and try the case in the face of this settlement would be pretty risky. And then the fees and expenses, this was a very well-lawyered case.
Yeah.
These are really good lawyers.
Yeah, good lawyers on this case. I have to say, I noticed that the minute you all came on screen, and it's good lawyers here. Yes.
Yeah, makes my job a lot easier.
Yeah.
But
Mine too.
The bottom line is I think this is an appropriate settlement for Olivia, and I would ask the court to approve it. We have a final judgment signed by everybody. However, there is an application to create trust, which has not been filed yet because not everybody has signed it, I don't believe. And then there's a separate order creating that trust, which will need your signature on. So rather than bombard you with emails, I assume you just want one email with both documents in it.
It's easier for my staff if you all put everything on one email and take the time to make sure that everyone's had a chance to look at it carefully and sign off. It is a little bit of a pain. I mean, of course we do it, but when people get rushed, they leave something out, they make a mistake, and then they try to get us to pull it back before the clerk has it or file a nunc-pro-tunc. So just you all make sure it's right, put it all in one email and send it to us before my signature, okay?
The good news is it's been reviewed. It's just logistically, I think there's a couple people that need to sign, and then I can get everything to you.
Okay, that would be great. Mr. Dow, as I said earlier today, just in the subject line, make sure that your staff write HO in the cause number so that we can see it's this case, and that helps us too to keep it in a order, because it's going into submission, and I sign all kinds of submission orders every day, and if I see HO, I know, okay, it's a hearing order. We've had him in, let's sign that first,
Yes, ma'am.
All right, very good.
I should mention that the judgment includes Mr. Dow's fee, which the Hatter Epiphany defendants are paying, and they have agreed to that amount. So we didn't just make that number up. It's everyone's agreed to that.
All right, very good. Anything else for the court before I make my rulings? All right, very good. So the settlement agreement is approved. The Olivia Wallace Special Needs Trust is approved and for creation. I believe those are all the rulings that you needed on the record. Is that correct, Mr. Dow, Ms. Weatherly?
I believe so, Your Honor.
Yeah.
Yes.
All right, very good. All right, so I will look for those then in my inbox. Mr. Wallace, again, as others have said, thank you for your service. We all owe you a debt of gratitude. Ms. Wallace, Mr. Wallace, I'm sorry for what you all have been through. I hope that this settlement does help in that regard. And our very best wishes then to Olivia as she goes forward in this life. And we hope that these funds help her to get all the benefits that she needs. All right?
Thank you.
All right, very good. If there's nothing else, you all may be excused.
Thank you so much for hearing us.
Thank you, Your Honor.
Goodbye. For Shelley Green versus Smith Excavating, set by defendant. May I please have announcements?
Yes, good morning, Eiserloh. My name is Chris Madrid for the defendants Smith Excavating and Paving and Trevor Smith.
All right, very good. Welcome, Mr. Madrid. And who else is here?
Good morning, Your Honor. Carol McCaney for the plaintiff.
All right, welcome, Mr. McCaney. All right, so this was set by defendant. I'm going to try to pull your case up on SmartBench real quickly and take a look at what you're wanting to compel. I will say on motions to compel, we find they go better if you can kind of, group the documents a little bit. Maybe you can't, but in the future, I sure wish you would. Kind of tell us generally what the objections are about. If there's any way we can kind of batch it a little bit, that can sure help us some when you pull up the motion to compel. When did you file the motion to compel, Mr. Madrid?
It was filed in early July or late June. I can get the date on that.
Let's see if I can see it here. Okay, so I've got your motion to compel up. I see it's a personal injury case. So apparently there was a written statement that plaintiff admitted she was on her cell phone when the accident took place. And the responding police officer at least attributed to that factor as a factor for plaintiff failing to respond safely. Defendant has requested the discovery of the cellular service provider of plaintiff to investigate liability. However, despite defendant's request, plaintiff has failed to produce the cell phone carrier information for review. For these reasons, defendant's request that the court order plaintiff to provide her cellular service provider on the day of accident. Is that right, Mr. Madrid?
Yes, Judge, that's correct. And I did have a chance to confer with plaintiff's counsel yesterday afternoon, in which we discussed potential and reasonable scope of what we would be requesting through subpoena.
All right.
We just discussed that we're really just seeking data for the hour pre and post accident. But still, to date, these discovery were propounded back in April. We still don't have the plaintiff's cell phone carrier. And that's why we're here before the court today, in order to request that the court instruct the plaintiff to provide the plaintiff's cell phone carrier at the time of the accident so that we can seek those records.
All right, Mr. McCamey, how do you respond to this?
Thank you, Your Honor. I did have a chance to, me and Mr. Madrid exchange a few emails yesterday regarding the motion to compel and the cell phone carrier. There have been, over the last month, maybe 6 weeks, there's been emails exchanged between Mr. Madrid and myself and also my staff. The explanation for the need for the cell phone carrier and cell phone information, and ultimately the alleged allegation, was based on a letter that was allegedly written by the defendant, Mr. Smith, in this case.
Okay.
Until yesterday, and actually before, prior to, when me and Mr. Madrid exchanged emails yesterday, up to that point, I had not seen the document that he was referencing. This document, my understanding is that the document he's referencing in his motion was produced in his responses to our discovery request. We have been trying to get those responses for a few weeks now. Mr. Madrid did serve them. However, he didn't serve them to my service email. He sent them to a personal, or not personal, another email address I have. It's not a service email. So that was the reason we didn't have them. So when I exchanged emails with him yesterday, I was kind of agreeing to agree to some limitation of cell phone users, based on thinking that this was some document that either came from an insurance carrier or that was, said to the police without seeing it. I've seen the document now, and Your Honor, it looks like a typed out letter. It's not signed by anyone. It's not verified. It's just and it's I'll be quite frank. It's not very well written. It has a lot of intelligibles. It's kind of hard to decipher what's being said. I believe it's being represented as if the defendant wrote this letter. But Your Honor, after reviewing it and after reviewing the file, I first would argue that there's been no allegation, no pleading of cell phone usage by the defendants yet. The defendants have filed 2 answers, one on behalf of the defendant himself personally, and then one on behalf of his company. There's no allegation in either of the answers of cell phone usage. It basically was a general denial. There was an objection to our gross negligence pleading. and also some language in there about offsets for insurance. But in the pleadings, the live pleadings in this case, there's been no allegations of cell phone usage. Also, there's been no pleading from either party or either defendant of contributory negligence. And in both of the interrogatory responses, interrogatory response number 3 to be exact, for both the defendant individually's interrogatory responses and his company, in interrogatory number 3, which asks for you to, let us know what your contentions are if you think that our client did anything wrong, acted in any way, negligently. There's an objection made there, but there's again no contention made of cell phone usage. So to date, Your Honor, the only mention of cell phone usage is in some typed letter, which I believe is being represented was sent by the defendant. I don't know when this letter was written. It was not signed by him. The interrogatories are not verified. And Your Honor, I mentioned this also. I think it's important. There's body cam footage from the police officer in this case. The defendant doesn't mention anything about the client, or excuse me, my client, the plaintiff in this matter, being on her phone at the time of the wreck. So at this point, and Mr. Madrid in his motion, he quotes the Couray Supreme Court case that came out in 2022. Everyone is using this case to substantiate their claim for being able to get cell phone usage. But in that case, Your Honor, and the holding is the request for the cell phone usage or for cell phone data needs to be based on some contributory factor. There hasn't been any pleading in this case of that yet. Your Honor.
All right, so let me stop you there. Sure. Mr. Madrid, what he's saying is, and I will say we typically do order cell phones turned over. It's one of those things, and boy, does it hurt to hear this on summary judgment, but I'm going to say it to you today. Doesn't sound like your request is supported by the pleadings. How do you respond to that?
Well, if it's just a pleading issue, that could be amended today.
All right, so here we are. The motion to compel, you know what? It's denied without prejudice. Get your pleadings in order. And I'm sorry to be that way, folks. It's old school, but you got to look at your pleadings. And really, folks, come on. It's easy to drop a general denial in, but you need to go in and start amending, because you get to trial and then you don't have anything. So in some ways, Mr. Mahaney's done you a favor today. All right. Your motion to compel is denied, Mr. Madrid. Respectfully, please get your pleadings in order. If you want to try to come back then and argue it again, I just think he's right at this point. And it's frustrating. I know I'm frustrated too, because I was ready to rule in your favor, honestly. But he's right now. So you need to get your pleadings in order. And will Mr. Mahaney please send us an order motion to compel denied without prejudice? And I expect that today by noon, sir. Okay.
Your Honor, and I'll just say also, I'm willing to confer with Mr. Madrid on this case. I mean, I don't want to play games here either and have to come back here. I'm willing to work with him.
This is a waste of court time, folks. And I'm being respectful, but this is the type of thing he's going to get those court records. He's going to get those cell phone records, and he's going to get it for an hour before and an hour after. That's perfectly reasonable, but it's not perfectly reasonable if he hasn't pled it yet, I don't think. So we need to have it. You all need to confer, get your pleadings in order, and get those cell phone records, because the case ain't going to move forward without it. Now, I understand he sent you something that you can't really rely on. You don't know what it is, and I'm with you. I don't know what it is either. I haven't looked at it, but that's not the same as writing in, your information about the cell phone and the pleadings. So let's get that done. And please, folks, try to work this out. Try to get those pleadings updated. Try to get the motion to compel resolved without having to come back to court again. Can we have that agreed, Mr. Madrid, sir? Yes.
I wanted to ask a question of the court. So we had propounded this statement back to the plaintiff in May. Trial is not set until next summer. Is it not appropriate for us to want to see the cell phone records before we amend the pleading on this?
Just amend the pleading now. Do it now. Why do you need to wait? You've told me you already have enough that you think that it's there. You don't have to wait to the last minute. This is state court. Is there some sort of order that you all have said that you can't amend the pleading without leave of court? I don't think so. Now, federal court, they will sometimes ding you on that. And we would ding you if you try to get things in after the pleading deadline, Mr. Madrid, but there's nothing stopping you from amending that pleading. So just amend it. I don't mean to lecture, but I think that for any plaintiff attorney or any defense attorney, when that case walks in the door, you do an interview. You don't want to base a pleading that's something you're pleading is based on nothing. But if you think you've got at least enough evidence to support, then put that in your pleading, whatever it happens to be, and then file it. And that way, at least you've got that. But there's nothing in state court other than a pleading deadline, which don't have right now, that's going to stop you. So, Mr. Madrid, amend it now, before you eat your lunch. Amend it so you have it. And Mr. Mahaney, you all get on the phone this afternoon. I'm tempted to put you in a breakout. In fact, you're in a breakout room right now. You all get this worked out. We're going to take on the next case. We'll come back to you. Sorry, but it's kind of a little bit of a waste of the court's time right now. So you all are now, Miss Guardiola, let's put them in a breakout room to get these things resolved, okay? And I'm going to want an agreed order from you. Thank you. Let's get them in a breakout room. I'm not trying to be mean, but really, we just need to get that resolved. Okay, very good. Now, let's go on to our last case, Cashers of Texas versus Bobby Wilkinson, Executive Director of the Texas Department of Housing and Community Affairs. We're here on their state's motion to dismiss. May I please have announcements?
Ben Stevens for the plaintiff, Judge PLS.
Okay. Hello, Mr. Stevens.
Good morning.
Good morning, Your Honor. Good morning, Your Honor. Brianna Cromingay for the defendants, TDHCA, and Bobby Wilkinson in his official capacity.
All right, very good. Ms. Cromingay, let me hear from you. Oh, hang on one second. Ms. Stevens, the family case who was here earlier. Ms. Stevens, we have reached out to your husband's attorney and we've not heard back from him. So you may go, but I would like you to please review whatever document he sent you and send any edits to that to the court as I instructed you, and make sure to CC him and the attorney, okay?
Yes, Your Honor.
All right. Who are you, Ms. Castro? Which case are you here on?
Ms. Castro's with my firm, Judge.
All right, very good. All right, Ms. Stevens, if you would please do that and send that to the court. If you could get to me by 5 o'clock today, I would really appreciate it. That email address I gave you, and so that at least we have the order that your husband, the father of your child sent, and your comments on it, and then I can make a ruling on that, okay?
Yes, Your Honor.
All right, thank you. Have a wonderful day, Ms. Stevens. I'm sorry that we took so much of your time. I was thinking we could maybe get the child's father on the phone. Just didn't happen that way. Okay. Have a nice day. Goodbye.
Thank you. Bye.
All right. So we're here on the state's motion to dismiss based on sovereign immunity. Ms. Cromingay, let me hear from you.
Yes, ma'am. Good morning. Your Honor, this suit is a claim, multiple claims, but the first is for inverse condemnation against the state. The second is for a declaratory judgment that the governmental officially capacitated defendant acted ultra-virously in executing a program which is administered by the TDHCA. And it's really a simple case, Your Honor. What it boils down to is that the plaintiff bears the burden in any suit against a governmental entity to establish jurisdiction and to establish in their pleadings that there has not been a waiver of sovereign immunity. In all cases against the state, there is a presumption of sovereign immunity, and it is only waived by express waiver in a statute from the legislature. And we don't have that here. And so while it is our motion, the burden rests with the plaintiff to establish that this court has jurisdiction over its claims, and it simply cannot do so. If you'd like to proceed into each argument, I'm happy to do so.
No, we've been reviewing your sovereign immunity arguments this morning. I suspect Mr. Stevens got some comment on that. So Mr. Stevens, now she's right. And I will tell you the thing about sovereign immunity is that it is a surprising and powerful defense. It will appear sometimes and completely foreclose a claim that one would think that has got to be actionable and a person cannot find a waiver. So tell me why you think there's a waiver here, sir.
Yeah, this is an interesting case, Judge. I agree with Ms. Cromingay that it is pretty straightforward and the facts are not complicated, but it is a little bit novel in that I think what the state has done is an inverse condemnation. No question the state's immunity is waived for a taking. This is not your typical taking where the state is coming in and condemning a piece of real property. The property interest here is a negotiable instrument, a check. The state wrote these checks to low-income Texans for rent relief during COVID. Some of those low-income Texans brought the checks to us, cashed them, endorsed them over to us. We then turn around and go to enforce the check against the state. The state tells its bank to stop payment. That checks every box for an inverse condemnation. A property interest that the state deprived us of the use and enjoyment of for a public interest without compensation. The state's only real argument that I've been able to discern in response to that is that there is an administrative process we didn't avail ourselves of. They don't tell us what that process is. In a year and a half of negotiations before filing suit, they actually told us there was no administrative remedy. And that's at Exhibit C to our petition, where one of Ms. Krominga's colleagues, Samantha Tracy, is telling my partner, Mr. Butler, there's no basis for jurisdiction for the State Office of Administrative Hearings here. You don't have a waiver of sovereign immunity. That's it. Go home. Well, there's only really one thing to do when you get that email from the state, and that's to sue. Why pursue some administrative option if the state isn't going to tell you what it is is in fact refusing denying that the SOAH has jurisdiction over this matter? I just think it's not the case here that we have to establish we exhausted administrative remedies. That's an affirmative defense to your pointers earlier.
Right, let's stop for a second here. I've not heard any argument of a failure to exhaust administrative remedies. Ms. Krominga, is there that argument being made?
Not explicitly as couched by plaintiff. I would like to address your question by answering a few things that opposing counsel raised. The argument that plaintiff does not have sovereign immunity in this inverse condemnation claim is twofold. The first is that there is no property interest, and that can be seen in our reply brief because the underlying funds for the negotiable instrument, the checks in this case, are a state benefit. And the courts in Texas have found that there is no vested property right in state public benefits.
Now you're starting to talk turkey. Now I'm kind of this like maybe there's an administrative review, maybe there's not, maybe they exhausted it, maybe they didn't. I wasn't following all of that. But when you're talking property interest, so tell me about this. So what you're saying is that there's case law that says that those government benefits, there's no vested property interest in it. Is that what you're saying?
Yes, Your Honor.
Okay, what's your case that says that?
Oh, I'm sorry. It's Hackney versus Meade out of the Third Court of Appeals in Austin, Your Honor. And the court explicitly said, and I'm quoting, relief for public assistance is not a vested property right.
Mr. Madrid, Mr. Mahaney, what are you doing back in this hearing? You all need to go off camera for a minute and I'll come back to you. Okay, thank you. All right. Sorry, go ahead. It's Mahaney versus Meade out of the Third Court of Appeals. And it says,
yes, ma'am. The court said in that case that relief or public assistance is not a vested property right held by any person or group of persons. It is a gratuity from the state made to those whose status and condition measured by standards promulgated by the State Board of Public Assistance show an urgent need for financial aid in order to maintain the highest degree of public health, morals, and general welfare.
Okay, that's nice. Tell me what the writ history is on this case. Did the Supreme Court look at it?
There's
writ refused, no reversible error.
NRE, yeah.
Okay, all right, very good.
Yes.
Now let's go back to you, Mr. Stevens.
May I respond?
The
Hackney case doesn't work here. That was a case where someone applied for welfare benefits. The state said no, and the applicant then sued the state for the welfare benefits.
So you're saying this is different?
This is a case where the governmental entity, via its executive director, Mr. Wilkinson, made an initial determination as to who is eligible to get rent relief checks. They then put the checks in the mail and send them to these low-income Texans. Some of those Texans go to their own bank and cash it. Some of them came to us. We then turn around and try to enforce the checks against the state, and the state says no. We are past to the point discussed in the Hackney case where there's been a determination about eligibility for benefits that was adverse. The state here made the decision that we were eligible for benefits, sent us the check, and then refused to pay. So Hackney, I'm not disputing anything Hackney says. It just doesn't work here. We're at a different point along the timeline.
Okay, let me ask you another question then about this. Now, doesn't it really the state has sovereign immunity in contract, right? Right, they do. I guarantee you, they do. Okay.
Not disputing that.
So they do. So, and y'all have a check here. But I think if they were acting as sovereign, there might be a waiver of the immunity. So where are we with this? I mean, that's what I think it kind of comes down to. Ms. Cromingo, let me hear from you on that one. I'm just curious what you have to say about that one.
Two things. First, to just touch on the Hackney case, opposing counsel is reading facts into the record that do not exist, namely that the executive director made eligibility determinations, rescinded those determinations. Importantly, Your Honor, in his governing authority under the Texas Government Code and the Texas Administration Code, and in the Consolidated Appropriations Act, which funds the TRR in this case, there is not a time frame which Congress or the legislature stated he must make an eligibility determination by. And so in refusing to apply the Hackney reasoning, opposing counsel is adding in a time frame and stating, and they do so in their complaint as well as in their response to our motion to dismiss, arguing something that the legislature explicitly did not say is a duty or requirement in the decision-making process for Mr. Wilkinson. And that touches based on the ultra-buyer's claim as well. But to your comment on the claiming contract, this is a really important thing to bring up because opposing counsel argued that it's our position, defendant's position, that they must exhaust all statutory remedies. No, what the case law says is that they must show that they are precluded by statutory remedy in order to bring a inverse condemnation claim, and they have not done so. He specifically references Exhibit C, which is an email that I was not on, it was my former colleague, but she actually says the opposite of what he offers this court, in that she doesn't say, you are precluded, we will not go forward. What she says is, you have not provided a basis for which you can proceed in the administrative court. If you have one, we would welcome that. And they didn't do so. Again, the burden is on the plaintiff to make their case. They're bringing these claims. I apologize. My light is automatic if I don't move enough.
That's okay. Mine does the same thing.
It's so frustrating. But furthermore, Your Honor, as you mentioned, it's very atypical that you see an inverse condemnation case with a negotiable instrument. In fact, we couldn't find a single one, and defendant doesn't find one either. And I think the reason is that the typical enforcement mechanism for a violation of Chapter 3 of the UCC is a claim for a breach of contract. And plaintiff, frankly, is aware of this, as they have sued a private party in federal court for this exact breach. And so our position is that they have not shown, as they're required to do, that they have exhausted any other statutory remedy. They're simply saying that we have not provided that remedy to them. And so they had to pursue a claim in under, I apologize, inverse condemnation. Now, even if this court found that they did exhaust their remedies and that they could properly pursue inverse condemnation because there wasn't another avenue, there again is no property interest because the funds underlying the negotiable instrument are a public benefit. And if we allowed that logic to apply, any state agency that issues a public benefit would be hamstrung to make a determination within a certain time frame that the legislature did not put on them. Those bounds just do not exist in their determination process as outlined by the legislature. And we can't read words into a statute that do not exist, especially when it comes to sovereign immunity. I mean, it's a bedrock principle.
Has to be waived by clear and unambiguous language. I'm very familiar. Yeah. Okay. Yeah. All right. So, let's go back to Mr. Stevens. Yes. Let me hear from you.
Ms. Cromingo alluded to, me referencing facts in the record. There are no facts in the record today except our allegations, which are taken as true for the purpose of this hearing. We've alleged an eligibility determination was made, checks were mailed, checks weren't paid. That checks every box for an inverse condemnation claim. You're not going to find a case that says exhausting some statutory process separately is an element of a claim. It may be a defense. It's not a defense the state raised. Their answer doesn't include failure to exhaust administrative remedies as an affirmative defense. So I don't think that's properly before the court.
All right.
But
go ahead.
I'm sorry, Judge. For the purpose of our pleadings, we've alleged the elements. That's all we have to do to get past the plead of the jurisdiction. And the second point of the contract, I acknowledge we couldn't bring a contract claim against the state like we could against a private party. That's why we alleged it as an inverse condemnation claim, the essence of which is we hold property of which the state has deprived us of the use.
All right. So I'm gonna ask you a couple of questions here. Hang on. Sorry, our Teams is out and I'm having to do everything kind of the old-fashioned way. Ms. Krominka's like, see, we're having problems with technology this evening.
She's in the dark. You're sitting.
Yeah, I could be in the dark soon too. Okay, folks, let me talk to you about this case. So here's a quote from the Texas Supreme Court in 2001. Texas courts have long recognized that the state wears two hats. Okay, the state as a party to the contract, and the state as a sovereign. The state, in acting within the color of right to take or withhold property in a contractual situation, is acting akin to a private citizen and not under any sovereign powers. In this situation, the state does not have the intent to take under its eminent domain. The state only has the intent to act within the scope of the contract. And in this case, I'm reading from the appellee, by making the contract, manufacturing the stamps and delivering them to the state, did so voluntarily and with its own consent, and cannot now say that the stamps were taken under the power of eminent domain. Okay, so that's where I think that's what I need y'all to focus on. Now, let me start with Ms. Krominka. How does that quote that I just read you, how does your case fit within that, which shows there has not been a waiver of immunity there?
Well, Your Honor, without having the case specifically in front of me, but based on the quote that you said, my understanding of the waiver of sovereign immunity when it comes to a contractual claim is that there are times in which the state might waive sovereign immunity to suit, but it will never waive sovereign immunity as to liability in a contract claim. And there are, I believe there's two provisions which do allow a waiver on a contract. One is under the Texas Government Code and one is under the, I apologize, Civil Practice and Remedies Code. And I believe they both relate to contractors, engineering, you know, kind of that sort. And so I don't believe that that applies in this case, that there is a waiver. And even if there was a waiver, there would not be a waiver as to liability. But again, a plaintiff has not brought a breach of contract claim.
All right,
they brought an inverse condemnation claim.
Let me hear from you, Mr. Stevens.
Can I rephrase your question, Judge, to make sure I'm answering the right one?
You can. And this case that I'm quoting to you all, this is General Services Commission versus Little Tex Insulation. It was in one of y'all's briefs. Go ahead, Mr. Stevens.
I think what Your Honor is getting at is whether the state has the intent here to take our property, or whether the state simply did something in its sovereign operations that renders it immune from suit, as in the case you're describing.
Why is the state not acting as a sovereign? I think that's our question.
Yeah, I think it's actually essential to our claim, and we've alleged that the state is acting as a sovereign. The state only condemns property in its sovereign capacity. It's when the state is acting as a sovereign, taking property for a public benefit, that inverse condemnation occurs. And it might be for something beneficial. I mean, I live in Houston. There was there were a ton of inverse condemnation cases after Hurricane Harvey when the Army Corps of Engineers made the decision, well, we're going to release water from the
Can you
reservoir.
slow down, counsel, please?
Yeah,
I'm sorry.
Slow down. We're on the record, right?
I forgot about that. The government made a decision in those flooding cases to release water downstream and flood 1,000 homes so that the reservoir wouldn't back up and flood 2,000 homes, right? This case, we've alleged, and again, those are the only relevant facts here, is what we've alleged, that we had a property interest. And I think the law supports that. We cited that law in our brief, that a negotiable instrument is a property interest. The state deprived us of the value of that property interest by telling their bank not to pay us. We've alleged they did it for a public benefit, for a public purpose. That's not been disputed by the state, as far as I know. And so for that allegation for today is true. That's all we need to allege. If there are other arguments that the state could make down the road with the benefit of discovery as to why Mr. Wilkinson did what he did, or if there's some other motive for it, that's potentially an argument that can be made down the road. But today, the issue is really just the sufficiency of the pleading. And did we check the boxes for an inverse condemnation claim? I think we did, for the reasons I've explained.
All right, very good. So let me hear from you, Ms. Krominka.
Yes, Your Honor. I would agree with opposing counsel in the sense that if the or when the state is providing a public benefit, it is acting as the sovereign. It is offering a benefit to the public. However, again, we do not believe that there's a property interest in this case because the well-settled law is that there is not a property interest in
government benefits.
In a government benefit. And frankly, there's not a case that we have found or that plaintiff has pointed to that supports their argument that a timeline must be put in place. And in fact, in canons of construction, the specific modifies the general. So even if they want to apply the UCC and say that the negotiable instrument is an unconditional promise to pay, the specifics of how to administer funds to individuals within the state of Texas must modify that. And the guidelines under which Bobby Wilkinson, as the executive director of the TDHCA, was to act and administer funds under the Texas Rent Relief Program are in the Texas Government Code, the Administrative Code, and the Consolidated Appropriations Act, not in the UCC.
Great. Let me go back to Mr. Stevens. So it seems that your clients have taken these checks voluntarily and by their own consent. I mean, I guess you would agree with that, Mr. Stevens. Is that right?
And for value, I would add, which is what makes us a holder in due course. But yes.
Holder in due course. Okay. So why can you come to court saying that there's a taking in that case, given that Supreme Court quote that I read to you a little while ago?
Because the essence of an inverse condemnation claim is that we hold property or have a property interest that the state has taken, either fully or partially. Again, I'll go back to sort of the real property condemnation example because I think it's useful here. If the state were to build a road through my home, well, I have a mortgage, right? My bank, that lien holder, doesn't have a real property interest. They have a paper property interest. I am making them payments every month so that they don't come to me and foreclose on my home, right? Well, if the state builds a road through my house and destroys the value of the collateral, they have to name my bank as a party to that condemnation case because my bank has an interest that's being affected by the taking. Again, we've alleged, Ms. Corminga apparently disagrees with my characterization of the timeline, but that's irrelevant today because what's relevant today is what we've alleged. What we've alleged is that Mr. Wilkinson made an eligibility determination. He says, John Smith, low-income renting Texan, gets a check. He mails the check to John Smith. John Smith comes to us, cashes it out for whatever reason. We pay him with funds from our bank. Then we turn around and go to the state to have the state's bank pay us. And the state's bank says no. That's a vested property interest. That's why we've couched the suit this way. It's because a holder in due course has every right that attached to the original instrument holder.
Okay.
If it's the case that Mr. Wilkinson, after he mails a check, can come back to the low-income Texan and say, you don't get money, maybe we're going to find that out in discovery down the road. It's not what we've alleged for purposes of today. What we've alleged today is that we had a vested property interest.
And Your Honor, to address, if I may, what opposing counsel just said, that they believe they're a holder in due course, and as such, they have the rights that the original recipient of the check would have. Well, the original recipient of the check does not have a property interest in the underlying funds, and plaintiff cannot create a property interest where one does not exist.
Yeah. No, I hear you on that. And obviously I guess the question also for Mr. Stevens is they took the checks willingly and by consent is what you would argue. Is that right?
I'm sorry, just who took the checks?
Your clients. I mean, that's the question, or I mean, I guess the ultimate beneficiaries on the check, because you're representing the payday loan people, right?
Correct. They paid the original recipient of the check.
Yeah. I would like to rule on this right now. I think we're going to have to look at it a little bit longer and see before I make a ruling on it. And I'm sorry I can't rule from the bench. I often can on sovereign immunity issues because I have a lot of experience with them, but I need a little more time on this. All right, we're going to take it under advisement. You all may be excused, and thank you for your arguments today.
Your Honor, might I ask, I just want to confirm, we touched on the inverse condemnation claim, but I wanted to ensure you didn't need argument on the ultravirus claim or the declaratory judgment for the ultravirus.
If you want to add something quickly, please do, but we are really running out of time. Okay.
No, ma'am, I just wanted to
go ahead. What do you want to say on the ultravirus claim?
I'm sorry. I think
what do you want to say on that claim?
Oh, it's in our briefings.
Okay. All right. We'll just read your briefing. That's good enough for us at this point, mostly. Okay.
Thank you for your time, Your Honor.
Thank you all.
To the extent, Judge, that you would like additional supplemental briefing, we're obviously happy to do that as well, to the extent it's helpful.
Yeah, I don't know that we need more briefing, but if we do, we'll let you know. Okay. Thank you both for your thoughtful arguments today and for your time. You may be excused, and I'd like to talk again to the folks on the motion to compel.
Thank you, Judge.
Thank you. All right. We're back with Mr. Madrid and Mr. Mahaney, and I had put you all in a breakout room to try to work out some problems so we don't have additional court time coming up. Mr. Madrid, how were you successful in that regard?
Yes, Judge, we've resolved the dispute. The motion is right now mute, I believe. Mr. McHaney was able to provide the cell phone carrier information.
Okay. All right. All right, Mr. Madrid, please don't forget to update your pleadings.
Yes, Judge.
Okay. All right. Very good. Mr. Mahaney, do you agree that the hearing is now moot? You fixed everything you need to fix on this?
Yes, Your Honor. Do you still need an order from me?
I just an order saying that that you all reached an agreement and it's dismissed as mute. That's all, and I'll sign it. Okay. And
Thank
send
you,
it to
Your
455.submission at traviscountytx.gov. And write HO, which means hearing order, and the cause number. And if you would get that to me by noon today, I'll get it signed. Okay.
Thank you, Your Honor.
All right. Thank you both. I appreciate
Thank
you
you.
taking the time to do that. Have a wonderful rest of the day.
You too.
All right. That concludes our docket. We've had some interesting cases, and I appreciate everyone's time this morning.